which shall be done only in the extreme of the circumstances. It's only yesterday that EACC themselves say that apart from all the accused persons, he's the only one who they have not served, or they didn't serve summons to attend court. They said that yesterday.
Only yesterday?
Yes, they said it yesterday, that all the accused persons, it's only him, my client, David Wanyama, the only one who they have not served summons. So that, Your Honor, was for good reason. Physical physical absence from the jurisdiction of this court. That is why EACC, a whole government institutions with the apparatus and machinery which they are not able to manage to find it. And today I've explained the reasons why, because I got my instructions yesterday at night. And the reason, Your Honor, is that this accused person was previously married to another accused person, Jen Wanyama, who appeared in court yesterday for plea taking and was released on custody. Previously married. So, Your Honor, when Jen was released, we frantically looked for him, David Wanyama, and finally we were able to locate him. Your Honor, this is a 2014 matter. 2014 matter. EACC has had more than 10 years to investigate this matter. We're only asking for up to 7th of May. The roof is not on fire. The roof is not collapsing on us now. You know, on that, I'm addressing the question of prejudice. We understand the legal process. The accused person understands the legal process. You know, this matter has a mentioned date on 14th of May. 14th of May. My client is indicating that he wants to come to court on 7th, before the mentioned date. So what prejudice conceivably does the state suffer in view of the practical difficulties which my client is facing? It is not correct to say that Tanzania is just a bus away. I'm talking about northern Tanzania. The other side of Lake Victoria. So it's not correct to make that supposition. So Your Honor, the state, assuming the warrant of arrest are issued, so will the state go to Tanzania to look for him, waste public resources? Yet I have made an express undertaking to court after communication with my client to come to court on 7th. And it will be a waste of public resources, total waste of public resources, for the warrants of arrest to be issued and then enforcement mechanisms to start. This is the first time they plea when the accused person is required to court to take plea. The first time, Your Honor. The first time. Then on the first date, it doesn't show up. The defense counsel comes with an explanation. The state applies for a warrant of arrest. Your Honor, in the practice of criminal law, that has not happened. The accused person shall be given some benefit of doubt. Especially when he is saying that he wants to come to court and take plea. Your Honor, the benefit of doubt principle, Your Honor, helps the accused person. But it will have been different if we are coming to court on the third, fourth, and fifth time, and then we are coming with this incessant excuses. Every time, Your Honor, an excuse. Every time, Your Honor, an excuse. That will be different. It will tilt in the side of the state, Your Honor. Your Honor, for now, I am begging. Your Honor, I like to refer to the book of Matthew 7, verse 7. First, ask, and you shall be given. Your Honor, we are requesting that we want to come to court on the 7th to take him. If you make an order that he comes to court on Thursday, it will be physically impossible to bring him to court on that day. Friday, so my Lord, I'm requesting for only up to Tuesday next week, which is 7th. Your Honor, Monday, working backward, just a few days, 3 days away, 3 working days away.
Mr. Wanyama, you're the one who had prosecuted miscellaneous E-114 of 2024.
Your Honor, the E?
The E-114, 2024.
Yes, he's not a party. It was prosecuted by.
He's not a party.
Yeah, the applicant is Jen Wanjiru Mbuthia, who took me yesterday.
Okay, he's not a party.
He's not a party to that case. Jen Wanjiru Mbuthia signed the affidavit, the only applicant in the matter, unless there's another matter somewhere which I have no idea about. So that chain, there is no link.
Mr. Wanyama, are you insinuating that it's only you can bring your client from Tanzania, the state is unable to?
Your Honor, that is not entirely correct.
Yes.
But now we are before the jurisdiction of this court. That accused person is represented. Your Honor, that should count for something.
I think that's a better way of saying things. What you are demeaning your own country when you say that a country cannot avail of fugitive.
No, my Lord, that is the public interest argument. The public interest, ESCC, instead of doing its work, now it goes to look for a suspect, who I have already informed the court will be coming to court on this stage. So what prejudice can they put public resources to a better use? That was just what I was saying. I'm not saying they are unable, maybe they have a huge budget. But public, it's not the prudent use of public resources. And Your Honor, on this one, the scale, it tilts slightly in my client's favor. Perhaps they can make a conscious decision before the plea taking to drop charges against this accused person. They can also decide to proceed fair enough. But as defense counsel, I have done my duty. I've also informed court, I've informed the state. As I said, I would really have failed if I don't bring this to the attention of court.
Okay.
But I understand the rules of evidence, I understand the parameters in terms of limitations now. But it was important for me to mention that.
Okay, Mr. Wanyama, you have mentioned that, and that's why I'm not, when I looked at the documents, that is evidential material. And as you have correctly said, you know the manner to present your evidence. But nothing stops you from approaching the prosecution in exchange of your documents, even in an attempt to enlighten them on the correct position on who is the director or who is not the director of the company. But for the court, I will not be in a position actually to take any material. Actually, that one we can't rest on record because those are evidential materials, which we cannot talk anything about it. Because as it is, even as a court, I can't make any substantive decision about an accused person who has not submitted himself to the jurisdiction of the court. So I wait, but for Madam Katero, and informal advice, you look at it. If it makes any sense, approach Wanyama, sit down, talk about it, and give us a solution. So that we don't end up in a balanced voyage. I think that one is key. My team you can tell to Mr. Wanyama that evidential material.
That's okay.
But Madam Kadero can speak about your client.
Yes.
The abstention, that's what you mean.
The absence, yes. Yes, Your Honor. On my part, on the part of the prosecution, it's my submission that there is no reasonable explanation which has been given by the advocate for the fourth accused person as to why his client has failed to attend court this morning. Your Honor, it was clear from even yesterday that all the accused persons who did not take yesterday were supposed to avail themselves and take leave this morning. Your Honor, Tanzania is not far. It is a country where a person should be able to travel even overnight and appear in honor of court direction. And Your Honor, I also wish to point out to this honorable court that the order for all the accused persons, apart from the first, the sixth, and the seventh accused person to appear in court for plea-taking were issued.
Other than the first?
The first, the sixth, and the seventh, who are initially the subject of stay orders in the Muranga petition.
Yes.
E004 of 2024.
Yes.
Your Honor, it was said that all the other people are supposed to have submitted themselves to court on the 29th. That is yesterday. Your Honor, it's therefore my submission that the fourth accused person had adequate time and information to enable him appear in court yesterday and also today. And Your Honor, based on that, I will be seeking for warrants of arrest against him.
And just in rebuttal.
Just a moment.